Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I will tell you one thing. When the Supreme Court is not willing to step in and stop some of this insanity from the lower courts, one of the things you will begin to see is that these lower court judges are becoming very creative writers. They have a very vivid imagination, and they can literally make stuff up out of thin air, thus proving that if their judicial career ever ends, they will all have a future as a children's book author. We're going to talk to you about a court where we've had success in the past, but we didn't have any success here. And it's an issue that candidly, the Supreme Court's going to need to step in at some point and do something about it. So today, let's spend a few minutes and let's talk about another court finds suppressors are not protected by the Second Amendment. Okay, America, we're going to talk about the challenge to Illinois' outright ban on the possession and use of suppressors. Many of you may not know this, but Illinois flat out bans them, as do a handful of other states. And Oregon, Washington, y'all better pay attention because this is probably coming your way as well. The case we're talking about today is called Morse v. Raoul. We have talked about the companion case once before, that is Anderson v. Raoul. Both of these matters consolidated out of the Southern District of Illinois, which you will recall was the original court in which we received victory on the challenges to the assault weapon ban, now coming up before a three-judge panel of the Seventh Circuit on September 22nd. So one would think that we would have done really, really well here. Well, understand here that the state of Illinois filed a motion to dismiss under Federal Rule 12b-6, which essentially says, hey, the plaintiffs here haven't even made a claim for a cause of action, so we ought to just dismiss the thing on the pleadings. Here's the bad news. The court has ruled, this court is called upon by plaintiffs to decide whether Illinois' outright ban of firearm silencers infringes upon the Second Amendment rights of its citizens. Defendants think not and move to summarily dismiss plaintiff's complaint via their motion for judgment on the pleadings. For the reasons explained below, the court will grant defendant's motion. Put other ways, the court has ruled, for the reasons stated below, defendants are entitled to judgment as a matter of law because the plaintiffs have failed to state a claim that is plausible on its face. Okay, so an outright ban on suppressors, a complaint alleging a constitutional challenge does not even state a claim at all in which action could be granted. It's as if the Constitution doesn't apply. Oh, you see where we're going here, because as the court put it, the threshold question is one of interpreting the Second Amendment's use of the term arms. Yes, you see exactly where we're going. The court is focusing on the definition of the word arms. That's right. You know exactly what they're going to find. They're going to find that suppressors do not constitute arms and therefore are afforded no Second Amendment protection whatsoever. The court went on to rule, but this court believes that plaintiffs pay too little attention to the majority's reference to Heller and its teachings that the term arms has a historically fixed meaning, but that modern versions of those weapons may still be included within the universe of arms. Okay, I want you to understand that arms have a acceptable definition going all the way back to the formation of the Constitution. However, suppressors, according to the court, did not exist whatsoever, neither did any other type of muffling or silencing device or anything such as that, and therefore could have never ever been contemplated under the guise of the term arms. Now, I know many of you are like, whoa, wait a second. Isn't there federal law that actually says that suppressors standing alone actually constitute firearms? Yeah, it's 18 United States Code Section 921, subsection A3C. But the district court in the Southern District of Illinois, well, they see it this way. Of course, these statutes do not suggest that Congress was adopting the definition of silencer to be included in the Constitution's universe of arms. But what cannot be overlooked is the fact that all federal statutes also regulate the use of silencers. So Congress's use of those terms does not shed helpful light on whether the framers would have classified silencers as arms. Put other ways, there is nothing there that tells us that they are constitutionally protected, but there is everything there necessary to prove that they can be regulated, and in this case, outright banned. The Southern District of Illinois believes that when you take a look at the definition of arms as announced in Heller, suppressors simply do not fall under the purview of that definition. They have found On the other hand, defendants reason that because silencers are not used to cast or strike another, do not contain or feed or project ammunition, and do not serve any intrinsic self-defense purpose, they are not deserving of Second Amendment quarter. The court goes through a very long-winded analysis of other attachments and accoutrements to determine whether or not they would be deserving of Second Amendment protections. And the court does acknowledge that there are some of them that are so critical to the actual function of the firearm itself that they clearly are afforded Second Amendment protection. But when it comes to suppressors, well, the court kind of sees it this way. While silencers are useful, they are not so critical to firearm ownership that firearms cannot be used effectively without them. Respectfully, there is nothing in Heller that suggests it is only firearm ownership and not firearm use that implicates the Second Amendment. And again, the court harkens back to the definition that was announced in Heller that constitutes a bearable arm. The Southern District of Illinois has concluded. To reach plaintiff's conclusion, one must ignore Bruin's finding that the Second Amendment's definition of arms is fixed according to its historical understanding. Plaintiffs offer nothing to suggest there is a fixed historical understanding that devices, which only serve to enhance operation of a firearm by reducing its reports, are arms themselves. Simply, if there was no colonial era or antebellum period archetype to a modern-day silencing device, it is difficult to understand how the framers would have understood the ordinary meaning of the word arms to include a device that reduces the report of a firearm. Now, I know, I get it, that many of you are like, whoa, wait a second. If that's where we're at, what keeps them from banning just about anything? Well, the Southern District of Illinois did pare that statement back a little bit because, again, they did mention that there are some aspects of a firearm, some attachments or accoutrements that are so critical to the functionality of the firearm, they ruled. At the same time, some attachments are so integral to the effective operation of a firearm that they might be logically included within the historically fixed understanding of arms. Now listen, I know what a lot of you are saying. These devices, suppressors, make the use of firearms far more simple. They make them far safer, especially from noise reduction. They make shooters more proficient. They are excellent training aids. There is absolutely nothing dangerous nor unusual about suppressors. You are absolutely correct. The Southern District of Illinois, however, believes that all of that is meaningless. It's worthless because they have ruled. The court accepts those statements as true. Neither does the court seriously question the truth of plaintiffs' allegations that silencers have become popular among law-abiding citizens of other states and are rarely used in carrying out criminal activity. These are all seemingly worthwhile attributes and useful enhancements to the safe operation of a firearm, and, if legislatively approved, might improve the chances that a law-abiding citizen will survive an encounter that requires reciprocal use of deadly force in their own home. But as useful and maybe even sound and wise it is to permit their possession and use, plaintiffs have not made a plausible claim that silencers are arms as the term was understood in the 18th century. And so with that, the challenge to Illinois' outright ban on suppressors has been dismissed at the trial court level. I do not know what the plaintiffs intend on doing, whether they're going to appeal this. Of course, they will be appealing this to the Seventh Circuit, so good luck with that. The cases, once again, is Morse v. Raoul as well as Anderson v. Raoul. We're going to go ahead and link up the rulings of the court down below so you can geek out on it for yourself. You don't have to take our word for it. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, which in Illinois is not much, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, all you do is click on that link right there to tell us all about it. If you want to subscribe to the monthly newsletter, the information on that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.
Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.